Good morning, everyone. So as Sanya has said, I'm here to present on the UNCRPD and its interaction with EU law. Firstly, I want to thank Sanya for inviting me here. It's always a great pleasure to be here in Trier. My presentation is somewhat more technical, I'm afraid, than Damien's because EU law is very technical in nature. I will try to keep it as non-technical as I can for understandability purposes. Okay, I think this quotation links quite nicely to the comment that was made by the Portuguese colleague over here in terms of the interaction between the law and the policy and what is happening at the legal and policy level and what actually happens on the ground. Indeed, many changes are happening at the legal and policy level, especially in the EU. There is a huge shift towards the values underpinning the CRPD. There's a huge shift in trying to align EU law with the CRPD itself. However, the application on the ground is very diverse, as our colleague has pointed out. So I think it's important to bear this in mind as I go through the presentation. There is a huge shift and many things are changing at the legal and policy level. It doesn't always mean that this is coming down to the actual application on the ground, unfortunately. And I will show you through some of the case law of the Court of Justice of the European Union, which has the power to interpret EU law and to decide on the relevance of the CRPD, the Convention on the Rights of People with Disabilities. I will show you how even though the court is saying many right things, it is trying to interpret EU law in alignment with the CRPD. In fact, on the ground, the interpretation is not exactly in line with the CRPD. So what I will do firstly is take you through the key provisions the key provisions of EU disability law and the key instruments that are relevant for your purposes in terms of EU disability law. And then look at the legal status of the CRPD in EU law and also at the national level. So again, this is a little bit complex and a bit technical, and I will try to break it down as much as possible. Then I'll just have a quick look at how the CRPD views disability as a concept. You might wonder why the concept of disability is relevant. In fact, it's very relevant since, as has already been pointed out, how we view disability really affects the application of the rights in practice and how they are received on the ground by people with disabilities. I'll then look at the CRPD's provisions for non-discrimination, but I'll focus on reasonable accommodation, so the duty of reasonable accommodation, because the concept of disability and the duty of reasonable accommodation are the two areas in which EU law is having or is seeing an effect of the CRPD. So these are the two areas that the CRPD is having most effect on EU law with regard to the concept of disability or the definition of disability and the duty of reasonable accommodation. And then I will compare, in a sense, how the CRPD views the concept of disability and the duty of reasonable accommodation to how EU law is actually viewing the concept of disability and the duty of reasonable accommodation. And finally then just some brief, I suppose, selected remarks on the impact of the CRPD so far on disability law in the EU. So I've broken it down into a few sections there in your PowerPoint slides. Hopefully it should be relatively easy to follow. The first part is about the actual provisions of EU disability law. So what are the instruments and the actual provisions that protect against disability discrimination in EU law, as well as the legal status of the CRPD. How is the CRPD viewed in EU law? And of course also in national law. So the first slide there is about the constitutional provisions. So the constitutional provisions refers to the treaties of the EU, so the main primary law in the EU. The principles of equality and non-discrimination in the treaties is firmly embedded at this point. Unfortunately, it was not always so. So pre-Amsterdam, before the Amsterdam Treaty, there was no explicit reference to disability in the treaties or in the primary law of the EU. So this was quite a big omission in terms of the primary law of the EU. No reference, no explicit reference to disability in the primary law of the EU. So in 1999, there was a big breakthrough with the Amsterdam Treaty when Article 19 of the Treaty on the Functioning of the European Union, the one in the middle there, Article 19 TFEU, was introduced, and the EU was given a competence to combat disability discrimination. So Article 19 of the TFEU is kind of a general competence of the EU to combat disability discrimination. So this was quite a big breakthrough in the legal framework at the primary law level of the EU. Article 10 of the TFEU is a kind of mainstreaming provision, and this provision was introduced after the Lisbon Treaty of the EU, and it's a provision that has horizontal application. This means that in all policies and in all actions by the EU is required to combat discrimination on the basis of disability. So it's a kind of mainstreaming provision across all actions of the EU. So this is also quite significant in terms of the change in the structure of the constitution of the EU and bringing disability into the mainstream of EU law. Article 114 of the TFEU is about the internal market, so all those barriers for people with disabilities in trade and internal market issues related to accessibility, etc. And the Amsterdam Treaty had a declaration which said that in taking measures related to the internal market, disability should be a relevant consideration. So again, we're going beyond discrimination, but we're actually looking at all barriers in the internal market. So together, these provisions form the basis of the Constitution of the EU and the primary law of the EU. In terms of secondary legislation, so below the treaties in the hierarchical value, you have various directives which protect against discrimination. For our purposes, the Council directive establishing a general framework for equal treatment in employment and occupation is the most relevant for our purposes. So this was introduced after the changes that I've just mentioned in the primary law of the EU. So this is secondary legislation of the EU. And it's very important to have a look at this secondary legislation since the Court of Justice of the EU is required to interpret this legislation in compliance with the CRPD. And therefore the case law that comes from this secondary legislation is also very important. And we'll have a look at that in a little while. So as I said, the Directive on Employment and Occupation prohibits discrimination on various grounds, including disability, but only in the field of employment and occupation. So currently that is where disability is protected in EU law, in the field of employment and occupation. The directive contains several provisions related to disability. One of the main ones is in Article 5 of the directive, which I think you have in the packs in front of you. Article 5 is the duty of reasonable accommodation, or refers to the duty of reasonable accommodation. And reasonable accommodation, as has already been explained by Damien, is an individualised duty to take appropriate measures, effective measures for people with disabilities to allow them to participate in everyday life. Of course, in the Directive 2078, it's only related to employment. So it's only related to employment, and there is currently only a duty to provide reasonable accommodation with regard to employment for people with disabilities. So a requirement to take appropriate measures in the area of employment to ensure that people with disabilities can participate in employment, advance in employment, access employment, and to provide training. So some kind of examples would be ensuring flexible working hours, times of work, etc., adapting these for the needs of people with disabilities. There is a requirement under EU law to do that. The duty is not unlimited. It is subject to a defence called the disproportionate burden defence. So if it is too burdensome for an employer to take such measures, then this can be a defence to the request for a reasonable accommodation. And the types of issues that are taken into account in this test are: does the employer have enough resources? How big is the company, for example? How many other workers are in the company? Organizational issues. So it's not an unlimited duty, it is subject to a test of disproportionate burden. Another instrument that is relevant to disability is the Charter of Fundamental Rights of the EU, which became binding in 2009 after the Lisbon Treaty came into force. So the Charter is basically to be taken into account by all EU institutions, agencies and bodies in their work across fundamental rights protection. The Charter aims to protect fundamental rights, as the title says, including with regard to the area of disability. The Charter also has to be taken into account at the national level when member states are implementing or applying EU law. So it's very important. It's not only for the institutions of the EU, but also the member states at the national level. And the Charter has a very high value in terms of a legal status in the EU. In fact, it has the same legal status as the primary law of the EU, as the EU treaties itself. However, it does not expand the competences of the EU. Therefore, with regard to disability, the competences as laid out in the treaties are still relevant. So the Charter does not expand the existing competences of the EU. So the provisions we've looked at are the ones that are still applicable in the context of disability and all other areas protected by the Charter. All of the Charter rights are relevant to people with disabilities. There are rights on education, social rights, etc., rights related to the elderly. So some of the types of measures may be relevant to people with disabilities. However, there are two particular provisions that I've picked out as being most important. Article 21, which enshrines the right to non-discrimination in the Charter, and this is relevant across all areas of EU law, all areas where the EU takes action. Article 21 has a right to non-discrimination. Article 26 then contains a very general right of persons with disabilities to benefit from measures to ensure their independence, social and occupational integration and participation in the community. However, before you get too excited about such a provision in EU law, which is quite a progressive provision, the court in the Glatzel case has said that this is not an actual right, an individual right of people with disabilities to have these types of measures in force. So it's not a directly enforceable right for a person with disabilities to have the right to independence and participation enforced under EU law. In order for Article 26 of the Charter to be effective, the EU has to actually adopt more measures, or these measures can also be adopted at the national level. So it's simply only a kind of principle to guide the EU in its actions rather than an actual enforceable right for people with disabilities. Okay, so that is the framework of EU law related to disability, especially related to non-discrimination on the basis of disability. How does the CRPD come into play in all of this? As Damien has already mentioned, the CRPD was concluded by the EU in 2010. So in December of 2010, the EU concluded or ratified the CRPD under Council Decision 2010 of 48. So this is highly significant because it's the first time that a regional integration organisation such as the EU has become a party to a human rights treaty. It also has great significance across policies and laws at the EU level, and which filters down as well to the member states. It also means that actually the EU is bound by the CRPD to the extent of its competences, to the extent of its powers. So the EU is obliged to act in conformity with the Convention and also not to contradict the Convention in its various actions. So that's significant. The EU, or from the perspective of EU law, the Convention is viewed as a mixed agreement. I think Damien already touched upon this. So this means that both the EU and its member states, when the EU concluded the CRPD, it became an international agreement which covers various fields in which both the EU and its member states have competence to act. So the EU is not solely responsible for implementation of the Convention. So it's very important to remember that not everything happens, of course, at the EU level. Also, the member states have competences to act under the CRPD. And the CRPD is way broader than EU law. Way, way broader. So it's not possible for the EU level to take all of the actions necessary to combat discrimination. One important issue is that discrimination is an area of shared competences. So both the EU and the member states have to share actions in this field. So it's up to both to take actions in the field of combating discrimination, and that's very important. Okay, we're almost finished with the technical overview, the status of the CRPD in EU law. What does it mean for the EU to have actually ratified and concluded the CRPD? Under primary EU law, Article 216, international agreements that are concluded by the EU, as I said already, are binding for the EU institutions as well as for all of the member states. So this is very important in terms of who should act and when. So both the EU institutions are bound as well as the EU member states themselves under EU law. Where does the CRPD come? How important is it in the hierarchy of EU law? It has been held that the CRPD prevails over secondary legislation. So we've already mentioned the Employment Equality Directive. The CRPD prevails over secondary legislation and indeed also over national provisions. It comes beneath the treaties, so it's not as important as the treaties or in the hierarchy. However, it must be taken into account once the once the Court of Justice of the European Union is interpreting the rights of people with disabilities under the Employment Equality Directive. So the CRPD must always be taken into account by the court. So this is a very important point to note about the legal status. Of course, the Court of Justice is the primary body which is responsible for interpreting EU law, for interpreting the Employment Equality Directive, and it has held that the CRPD forms an integral part of EU law. So in other words, the court finds that the CRPD is highly important to the interpretation of the rights of people with disabilities in EU law. So this is also a very fundamental point. So that is the status of the CRPD in EU law. Technically, it has a very high status, in fact, in EU law. How about then in the domestic legal orders? The question is a bit different since this goes down to national constitutional law, which is different in every country. And how is the CRPD being received in national constitutional law or in member states of the EU? In fact, the CRPD is having a type of indirect interpretive effect. This means that it's actually been drawn upon by judges, in some cases, to either overturn or reinterpret cases or legal doctrine. It's also been used to fill some gaps where the judge is not, for example, sure of how national law should be interpreted, so it's been used to fill the gaps in the unclarity at the national level. And it's also been used to kind of support other legal authorities at the national level that support the rights of people with disabilities. So there is recent literature from Waddington and Lawson, a very interesting book, which highlights how the CRPD is being used across a huge number of states parties to the CRPD, a very interesting book. So this shows that both at the EU level, actually, and at the domestic level, the CRPD is highly significant in terms of at least the laws and policies. This doesn't mean it's working out in practice, sadly, but at the application level and the interpretation level at the EU, in the EU sphere and national spheres, the CRPD is very important indeed. This takes us then to the CRPD itself. What does the CRPD say about the two areas that I mentioned? So I said that I would focus on the concept or the definition of disability and also the reasonable accommodation duty and how these are impacting on EU law. So these are actually just the two areas where the CRPD has had the most effect, and that's why the focus lies there. I don't want to repeat too much what Damien has already elaborately presented, but it's important just to recall the various shifts that have taken place in how disability is viewed, from the medical model to the social model, or the social contextual model as I call it, to a human rights model of disability. And this is called the paradigm shift in how we view disability and how judges and how laws and policies are supposed to view disability. So the medical model, as we all know, has focused on the actual impairment. So the actual impairment is the focus of laws and policies, is the focus of what judges are looking at, and the attempts to actually cure that impairment. Because if we don't cure it according to the medical model, the person will not be able to fit in with the norm of everyday society. And the medical model has been underlying disability laws for so long now, as was already pointed out. The CRPD has moved to looking at the interaction between the impairment and the barriers in society. So this can be either physical barriers, stairs, ramps, or lack of ramps, etc. It can be barriers in attitude, so where people have false assumptions about people with disabilities. They think they are not able to do certain things, so these can be also different types of barriers. And the CRPD focuses on the interaction between those impairments and the barriers in society. The CRPD committee has endorsed the human rights model and simply builds on the social model to view disability as a social construct. So it is the interaction of the impairment and the barriers that causes the disability in society. And the human rights model views people with disabilities as holder of rights on an equal basis with everyone else in society. Very importantly, from the point of view of the CRPD, and this comes into the case law of the Court of Justice later on, the two provisions in the CRPD that are the most relevant for your purposes are the preamble in recital paragraph E and Article 1 of the CRPD. So these two provisions very clearly show that their disability is caused by that interaction. So not only is the impairment relevant, but it is most importantly the interaction with the barriers in society that gives rise to a disability. So the role of societal barriers is very clear in those words that I've highlighted in yellow, in those two provisions of the CRPD. And this is the social model or the social contextual model of disability. Now, as to the actual prohibition of disability-based discrimination in the CRPD, you need to look at Article 2 of the Convention and look at the definition in Article 2. It is such a wide definition. It includes all forms of discrimination. This is potentially unlimited, and the CRPD committee has interpreted it very widely, as we will see later on in my presentation after the break. all forms of discrimination, but most importantly, including an unjustified denial of a reasonable accommodation. So if a person with disabilities needs a reasonable accommodation, asks for it, and it is not a disproportionate or undue burden, this will be discrimination if it is not provided to them, according to Article 2 of the CRPD. The definition then of reasonable accommodation I won't repeat, but you'll find it also in Article 2 of the Convention, so there's a very specific definition which I have already explained earlier. Also, Article 5 of the CRPD says that states parties are required to ensure that reasonable accommodation is provided. And this is very broad. It means not only public entities have to provide reasonable accommodation, but also indirectly private entities have to provide reasonable accommodation. So it's a very wide definition of reasonable accommodation as well, and a very wide prohibition of disability discrimination. So they are the various provisions of the CRPD that are relevant to the concept of disability and the duty of reasonable accommodation. So what I want to do now is just go through the various cases in EU law. I'm sure you're familiar with some of them, which touch upon the concepts of disability and which touch upon also the definition or the duty of reasonable accommodation, to see how the CRPD is impacting on EU law, especially at the case law level. As I said earlier, the court is really making a very strong effort, let's say, to align its definitions with the CRPD, but this does not always work out in practice when you look at the wording of the court's definition. Okay, so the concept of disability is the first point that I wanted to address, or the first area. As I said already, the main law that applies here is the Employment Equality Directive in EU law. It does not define the concept of disability. So this gives the court momentum to look to the CRPD to define the concept of disability under EU law. And that's exactly what the court has done. It has looked to the CRPD to actually draw out the meaning of the concept or the definition of disability. And the definition of disability is very important under case law, since it decides who will be protected from disability discrimination. So it's very important that you fall under the definition to get the protection in the first place. There's a lot of literature on the issue as to whether the court's definition is actually compatible with the CRPD or not. So I have listed the literature there in the PowerPoint slides. Some of it is really worth having a look at to see how the court is dealing with the concept of disability. I've also listed the cases there. They should be in chronological order. I'm not going to have time to go through them all, but you might be interested to have a look at some of the cases. Some very interesting ones, such as the Coleman case there, the second case, where discrimination by association was held to be a form of discrimination for the purposes of disability. So in other words, a mother who had a disabled son was entitled to protection under EU law, even though she herself did not have a disability, but she got the protection through the discrimination received by her son in that case, and this affected her under EU law. Okay, so just to pick a couple of the cases that are the most relevant in terms of how the court is viewing the concept of disability. The first case that reached the court on this issue of the concept of disability was the Shaka and Navas case. I'm sure you're all quite familiar with this case. This came before the CRPD was concluded, before the CRPD came into effect. So obviously we would maybe not expect the court to have a very progressive interpretation, since it was before the CRPD. This case concerned a woman who, as a result of sickness or illness, had been absent from the workforce for quite a long period of time, and she was dismissed as a result of these absences. And the question before the court was, does she have a disability? She is sick, but does this amount to a disability under EU law? And that was relevant because in order to get the protection under EU law, we need to prove she has a disability under the Employment Equality Directive. So the court came with its very, let's say, limited understanding of disability, and this is obvious that the court had not actually ratified the CRPD at this time. The court said that a disability under the Employment Equality Directive is a limitation which results from various impairments. So these can be physical, mental, or psychological impairments, and which hinders the participation of the person concerned in professional life. So I've highlighted the most important words. As you can see, the court related disability directly to the impairment, did not take into account any barriers in society. It simply focused on limitations that result from impairment. And that, as we know, is the medical model of disability, as I will discuss in a minute. The court did say various things that were of great relevance. The court said for any limitation to be regarded as a disability, it must be probable that the limitation will result or will last for a long time. So this means the court sees disability as being a more longer term thing rather than a sickness of a short term duration. So that's very important. And the court said disability is different from sickness. The Employment Equality Directive does not protect in the case at issue. So in the case where she had a sickness and was absent from work for a particular amount of time. Okay, so I've just some brief remarks. As I've already mentioned, this definition is very much based on the medical model. It doesn't at all take into account environmental barriers. It simply links the limitation directly to the impairment. So disability is seen as arising from the fact that there is an impairment in the first place, which is a very narrow view of disability under EU law. So according to the court, the cause of the disadvantage in the particular instance was the impairment itself, and the fact that the impairment hindered participation in working life or in professional life. And therefore the court simply saw the problem as lying with the disabled individual and not with social structures in a more wider sense. So that was the first case that came before the court on the definition of disability before the CRPD came along. So it was only in 2013, actually, when the CRPD had already been ratified by the EU, that the CJEU, so the Court of Justice of the European Union, had to react again on the concept of disability. So this was the next time that the court was asked to reflect on what disability means under EU law. The facts of this case were quite similar to the Shakan Navas case. They concerned absence from work and a dismissal based on that absence from work. So in this case, the Danish court referred various questions to the European court, mainly concerning what does disability mean under EU law. And the court held that the Employment Equality Directive prohibits discrimination on the basis of disability, and for that purpose, for the purposes of determining protection, the concept of disability must be understood as, and I have the definition outlined there, it must be understood as a limitation which results from an impairment which, in interaction with barriers, hinders participation. So there you can see that the court added that little bit in the middle about the interaction with barriers in society, and this was directly influenced by the CRPD. So the court has changed its definition of the concept of disability under EU law in this famous case, HK Denmark. So the court very purposely aligned itself, or attempted to align itself, we'll say, with how the CRPD views disability. It specifically cited the provisions of the CRPD that I mentioned earlier, so the preamble of the CRPD, also Article 1 of the CRPD, when it developed this definition of disability. So there was a purposeful kind of attempt by the court to move towards the CRPD. We can definitely say the court has moved away in theory from the medical model of disability towards a more social model approach, because it has said barriers are very important in society in determining if there is a disability. However, the wording of the court's definition, and particularly the first word of the definition, the limitation, has been the downfall in some ways of this definition, because it actually limits the protection under EU law, or could potentially limit the protection, as I will show you in the next case. So after the HK Denmark case, after the court's very progressive interpretation of what disability means, we had the Countif case. And this case was about a man with obesity who worked for a public authority. He was working there, I think, for 15 years as a childminder. He was dismissed from his role. The public authority said he was dismissed because there weren't enough children to care for at that particular moment, and that was the reason for his dismissal. However, he was obese, and he had suspicions that the public authority was taking this into account in dismissing him, so that the obesity was somehow responsible for his dismissal. The question then was, is obesity a disability under EU law? This is a very important question given the rising levels of obesity. So the court was asked to reflect on this issue. Can obesity constitute a disability under EU law? And the court held that obesity can be a disability under EU law only if it meets the definition of disability that the court had already outlined in the previous case. So in the HK Denmark case, and I've highlighted it there in yellow, if it meets the definition that it entails a limitation resulting from an impairment which interaction with barriers hinders participation in professional life. And in the case of Countif, the court gave some examples of what type of limitations apply in the context of obesity. So how could a person fall under the definition of disability if they have an obesity? And the court said a limitation could be, for example, if the obesity hindered mobility of the person, if the obesity resulted in other medical conditions that prevented that person from carrying out everyday work. So they were the types of limitations that the court gave, and the types of examples of limitations. As you can see, they are solely physical limitations. So the court focused on very physical limitations. It did not look to barriers such as attitudinal barriers. So if the public authority had thought Mr. Countif could not do his job. In this case, actually, Mr. Countif said, I'm perfectly able to do my job. I am obese, but I have no limitation resulting from my obesity. So in fact, I'm perfectly able to do my job, despite the fact that I'm obese. So the court did not seem to look to the types of attitudinal barriers that might arise on the part of employers. So my remarks are that on the one hand, the court has somehow expanded its approach. It is potentially including obesity as a disability, as long as it matches the definition of the court. However, on the other hand, the court is not saying that limitations that are not physical, so attitudinal barriers, are covered. It doesn't say the opposite, but it does not lead us to believe that such type of attitudinal barriers might be covered under the court's definition. So this is problematic, since many barriers faced by people with disabilities, especially those who are obese, come from these types of attitudinal barriers. So I believe the court is not fully in line with how the CRPD views disability. The CRPD views barriers as any type of barrier: physical barriers, environmental barriers, barriers in attitude, etc. So it's not fully in line with the CRPD in that respect. Another case which is also relevant and shows that EU law is not still fully in line with the CRPD is the Zed case. And this case was about a woman who had no uterus and was not able to conceive a child. Herself and her husband went to America to pursue surrogacy options. When she returned to Ireland, she was not given paid leave from her employment. Since she had not had a child, she simply had gone the surrogacy route. So she was not given paid leave from her employment, as normally a woman would be entitled to such paid leave. The question was, is this refusal to provide her with paid employment leave after the surrogacy birth in contradiction or in not compatible with EU law? In other words, did Mrs. Zed experience discrimination on the basis of disability? And in this case, the question was, is her inability to conceive a child naturally a disability? So that inability to have a child naturally, is that counted as a disability under EU law? And the court said, as I've outlined on the slides, Mrs. Zed did indeed have a recognised limitation resulting from her impairment. So the inability to conceive a child naturally could be seen as a limitation which potentially could amount to a disability. However, in our cases, it didn't amount to a disability because the court said it does not impact on her ability to work. So the fact that she cannot conceive a child has no relationship with her ability to take part in the workforce. And this is a very limited understanding of disability-based discrimination. Of course, it's natural. The Employment Equality Directive is about employment. Therefore, we understand that the court wants to limit it to discrimination in employment. However, she was refused employment benefits. So she was refused employment benefits in this case that other people would get if they had a natural pregnancy. So the types of benefits she was refused definitely came into the field of employment, and therefore the court interpreted disability in also somewhat of a restrictive manner, much narrower than the CRPD. So the CRPD views disability as being any type of barriers experienced in society in general, so across all areas of life of a person with a disability. So the court's narrow approach had led to Mrs. Zed being denied employment-related benefits that normally should have been covered under the directive because she did not meet the definition of disability adopted by the court. So again, a narrow interpretation. Last case is Mohammed Dowdy, and this case was also important with regard to the definition of disability, since it clarified that limitations resulting from impairments must be long-term in some way. So again, the long-term element of the impairment and the limitation is very relevant. And the court said it's up to the national level, the national judge, to decide what is long-term and to decide whether a particular disability or impairment is long-term in fact. But the court just gave some types of examples of what long-term means. And the court said that a limitation may be deemed long-term if the incapacity of the person does not display a clearly defined progress or prognosis as regards short-term progress. In other words, anything that's not short-term is long-term. Or the fact that incapacity is likely to be very prolonged before the person has recovered. So anything that is not short-term or deemed to be short-term is viewed as long-term according to the court. The problem with this is that the court said the time at which we look at the prognosis is the time of the alleged discriminatory act. So at the time of the discrimination, we then check if the prognosis is long-term. And this can have problems since some disabilities are viewed at that time as being short-term, but they actually end up being long-term, and vice versa. So the court's approach is a little bit restrictive in that sense. By saying that we look at the time of the discrimination, it's restricting. Also, the court said we must have an emphasis on objective medical evidence to decide whether something is long-term or not. As we know, this is very difficult, especially with psychosocial impairments or other types of impairments that are not physical impairments. To rely on objective medical evidence is also could give rise to various issues at the national level. So all in all, I would say that these cases illustrate the court is really trying very hard to move towards the CRPD's understanding of disability, but is not quite getting there, I would say, in the practice. Just very briefly on reasonable accommodation, the second area that I've been asked to speak about. Does EU law or are EU law and the CRPD in alignment when it comes to the duty to provide reasonable accommodation? In many respects they are in alignment. However, the CRPD on the one hand defines an unjustified failure to provide reasonable accommodation as discrimination. So once I ask for a reasonable accommodation, it's not a disproportionate burden and it's not provided to me, it's a form of discrimination under the CRPD. This is not the case under EU law. So Article 5 of the directive, the Employment Equality Directive, does not specifically say that a failure to provide reasonable accommodation is a form of discrimination. So there is a new proposal for a new non-discrimination directive that was brought forward in 2008, and this proposal does define discrimination, reasonable accommodation, and the failure to provide reasonable accommodation as a form of discrimination. But the proposal is not currently adopted. So the court, in none of its case law, has commented on this issue, whether reasonable accommodation and the failure to provide reasonable accommodation is actually an explicit form of discrimination under EU law. The final point then relates to how the court and how the CRPD view this concept of reasonableness. What is a reasonable accommodation? What does reasonable actually mean? The CRPD committee has been very clear on this. Reasonable means something that is actually effective and practical and will result in the person with a disability being able to participate in everyday life. So reasonable does not refer to the cost issue. The cost issue is a separate issue to be taken into account under the test of disproportionate burden. So it's a separate issue to whether an accommodation is effective, and that is the meaning of reasonableness in the accommodation duty. The court, however, does not seem to be of the same view. So if you look at paragraph 58, for example, of the HK Denmark case, the court seems to align reasonableness with cost. And this is quite problematic, I would say, since it means that a person could be denied a reasonable accommodation by looking at it in this way. So the cost issue should be a separate issue, determined under the test of disproportionate burden. So it's very important that the EU law would align with the CRPD on these definitions. And several EU member states go with a similar approach to the court. So they define reasonableness in terms of a cost issue. So that is quite important to note. Okay, so finally, after all the technicalities, impact of the CRPD on EU law. I think it is having a very considerable impact on EU law, not only at the case law level, at the Court of Justice level, but also with regard to moving the EU forward to take other actions related to disability. We have the European Accessibility Act, the proposed Non-Discrimination Directive, which prohibits disability discrimination in several areas, including access to goods and services, including housing, social housing, education. Unfortunately, the Non-Discrimination Directive has not been adopted. The Accessibility Act has recently in March been adopted by the Parliament. So there is a lot of movement at the EU level in terms of the CRPD and how the CRPD is influencing. Unfortunately, I don't believe, and many people don't believe, that actually the court's definition of disability is fully in line with the CRPD. So this is problematic. Finally, the CRPD Committee's concluding observations to the EU. So one of the main ones was to adopt this proposed directive, which would bring the definition of discrimination outside of employment alone. So it would look at education, access to goods and services, and as well the provision of reasonable accommodation in those areas would be seen as a form of discrimination. So it would be very important, according to the CRPD Committee, that the EU would adopt this proposed non-discrimination directive. Thank you very much.